Alrighty, my EPD 275 peeps. In the first video, I showed you what Walt Disney could do with storytelling, and now we're going to talk about how Walt Disney could protect himself now that he developed the technology. So this is what's called intellectual property. It does sometimes get dry. Apologies ahead of time, but you know me, try to make it entertaining for you. But the real story behind intellectual property is how to protect yourself and your others, and we're not talking about a COVID mask here. We're talking about from a legal standpoint. So let's get started. All right, so here's a video I want you to watch. It gives a great summary from Durham University.
What's intellectual property got to do with you? More than you might think. Intellectual property is everywhere. Here, 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 and here, 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 and even here. It's in our nature to create things, and intellectual property, or IP, is the legal way we can protect them. Things like books, music, brands, products, and even inventions. This protection has encouraged innovation in all walks of life. After all, what would be the point of having a good idea if anyone could take it? Hey! To put this in perspective, the Coca-Cola brand was recently valued at $84 billion, its most valuable asset. But it's not just about big business. This affects all of us. If you have an idea or create pretty much anything, you're probably going to want to protect it. Unfortunately, rather than there being one nice simple law to call upon, IP protection comes in 4 delicious flavours. Well, they're actually rights. Trademarks, copyright, patents, and design rights. Trademarks are used as a sign of origin of a product or service, and they are everywhere. Google, Nike, really, this is the cleanest you could find. Apple all have instantly recognisable trademarks. Perhaps less well known though are trademark colours. Heinz actually has trademark protection on the blue colour of their baked beans, and it's even possible to trademark a sound. Trademarks must be able to be represented graphically. Sounds can be scored. They must be distinctive and not be descriptive. You wouldn't be able to get a trademark for a company selling apples called Apple. Yet it's fine for computers or records. Anyone can use the TM sign without registering, but formal registration must be granted to use the R sign. Registration can be done easily and cheaply on the IPO website, and doing so prevents others from copying your brand identity. Copyright is an automatic right that does not need to be registered. It exists whenever anybody creates an original work, providing there's been some skill or judgment involved. Examples are books, pictures, music, films. This film itself is protected by copyright. Dissertations, talking of which, plagiarism isn't just cheating, but you wouldn't do that, would you? It's also copyright infringement. It also covers computer programs and databases. But there's a slight catch. Copyright protects what's called the expression of an idea, but it doesn't protect the idea being expressed. So if you write a brilliant piece of software, the code you've written is protected, not what the software does. Copyright works are protected for up to 70 years after the death of the person who created them. In that time, they can't be reproduced, rented, performed, or shown without permission, even if it's on the web. And the copyright owner can recover damages from anybody who infringes that. However, permission to copy works can be granted, usually in return for payment of a license fee or royalty. That's how music streaming websites do it. Next up is patents, the big guns of the IP world because they're powerful, potentially very valuable, and often really complex. They protect inventions providing they are new, involve an inventive step, and have industrial application. Tetra Pak have utilised patents for the machines that make these cartons. They've become a multi-billion-dollar company thanks to a process that folds cardboard. Without patents, drug companies wouldn't invest the enormous sums needed to develop new drugs. but the protection only lasts for 20 years, and it can take more than 10 years to bring a drug to the market. That's one reason why new drugs cost so much, yet out-of-patent drugs like this ibuprofen only cost 4p. If you ever have an idea that you think could be patented, there are 2 key things you should do. Firstly, don't tell anybody. Seriously, don't. Secondly, get some help from a patent attorney. The world is full of patent applications that lawyers can drive a bus through. Don't let yours be one of them. Design rights protect what things look like, their shape and appearance. That could be something as mundane as a coat hanger. Or something more iconic. Like copyright, design rights are automatic, but they only protect for 3 years if they remain unregistered. If registered, they can provide protection for up to 25 years. IP is there to encourage innovation by ensuring those that have great ideas can benefit from them. For more information, visit the IP Tutor on the Intellectual Property Office website.
Video out of the way. So, why should you care? Well, first of all, you need to be aware if you're violating it. In school here, we kind of more worry about plagiarism. Once you get out of the world and you do great things, you're going to want to protect it. So you want to know if someone else has invented it and has rights to that technology. So it protects the work of individuals. It's how it's used, and also it's about who can lay claim to it. But more importantly, it protects you and your knowledge. Because once you go on and do great things, you want to make sure you not only get credit for it, but you want to get money for it. And the question is, if you create it, how do you protect from someone else from taking it from you and making more money? So that's where intellectual property laws have come into place, and that's why we're talking about this. So what is intellectual property? Well, believe it or not, it could be as simple as your grandma's secret recipe for the best apple pie you've ever tasted, especially after multiple awards at the county fair. But, you know, it's kind of funny. She won't share the recipe with you or anyone because she's worried about you stealing it. Yeah, in her older age, she's kind of gotten a little senile. But that is what's actually called a trade secret. So she's keeping it to herself, and she's protecting her intellectual property about her award-winning apple pie. In the company, this is the same. It could be a process used within the company to build something, or even how it analyzes information. It could be a product that's being produced, could be that is being produced, or even might be produced. In the future, in the presentation, you'll come across this IP. Some of the types of IP protection: copyrights. This covers software, literature, music, art, and slogans. How you achieve this is through the U.S. Copyright Office, which is a federal agency. You apply to it, you pay the application fee, and then after you've been approved, you can apply the the Circle R, Circle C, TM logos. Now, C, copyright can be used without registering, but R must be registered with U.S. Copyright Office. So kind of like R is the more stringent where in case of legal, it's much more stringent and can be supported in a courtroom. And that lasts for 70 years after the author's death. So, you know, if you make a great movie, it's copyright while you're alive, but everyone else has to wait for 70 years till after you die before being able to use it for free. So, and if you ever heard of the birthday song, Happy Birthday to You, yeah, that was a big thing in the 90s where it was still copywritten. But moving on, trademarks. This is called a special form of copyright. It protects a name or slogan. So it lasts for 10 years with renewals for 10 years afterwards. And what's actually kind of funny about that, as mentioned in the video, you can call yourself Apple, but you can't trademark the actual fruit. So it has to be something a little bit different. So that one, if you get down that point, I suggest you actually just talk to a lawyer or someone who can point you in the right direction. But I just want to make you aware of the trademarks here. Next is trade secrets. This is going back to your grandma's famous apple pie. They're formula, practices, processes, instruments, patterns, or compilations that I'll value. The alternative here is to a patent because it keeps it secret. So believe it or not, Coca-Cola is not patent, it's a trade secret. Because so what they do is they just keep the recipe in a vault, nobody knows about it, and as a result, it never expires, and that's how they keep the world from creating a different version of Coca-Cola. Now, a little more involved, well, they're much more involved, I should say, patents. It gives the owner a legal right to exclude others from making, using, selling, and importing an invention. The danger here is it requires a public disclosure, which is a risk and can always be copied, especially when it comes to software. So believe it or not, you actually want to use a trademark or copyright for the software rather than the pen, because a pen goes to the patent office and everybody can see. And you can't patent what happens with the software. You can only patent how the software operates. So if you're able to make a presentation with something, if you want to make, if Microsoft patents Microsoft PowerPoint, well, Google Slides is very similar and they get to a different way. So are you violating the patent? Is Google violating the patent with Google Slides? No, Microsoft owns a patent for how the software works, but not the product. And since that's how both can use the same end with the same end product. There's a few points here for patents. You have to have prior use claims, which means you had to have invented it and used it. Companies will sometimes apply for patent to be able to use in the future or even signal to competitors to what they're working on. One of my favorite patents I saw there was stackable seating in airplanes. Yes, this is where in Coach they would put seats on top of each other. So I'm not sure if there's a signal from Boeing to Airbus about what they're working on, but Boeing never implemented it. But it's patented, and everyone was able to see what they're doing. Now those patents are good for 14 to 20 years. We can go into details about the medical field and biomed. Wow, that's such a short time span, but it's good for 14, 20 years. I believe you can renew it. I can't remember offhand if you can or not, but I believe you can. No, I believe you cannot. Now I think about it. All right, other types of IP anyways. Industrial design rights protect the visual design of objects. Plants varieties, rights to protect how that new version of your tomato plant is created. There's even trade dress, which is protection for packaging and appearance. So for example, if you wanted to have the golden arches, which we know with McDonald's, you can't just put the golden arches on your product and call it the Donald. So there's protections of all that. Mainly the main goal here is just to introduce you to the concepts, not to analyze them. So strategy for IP. Ask yourself, is there anything I need to protect in this presentation? Academia is fairly open and shared, although you have to give credit or a citation. But this is not the same in the business world. In fact, if you're in the business world, you never let intellectual property off your PC without a copyright. Don't even try to store it in servers. Even carry them in USB drives instead. So that's just a warning. If you're giving a presentation, uploading a presentation to a conference, be careful. They might actually share it. And how you protect yourself is prior to emailing that presentation or report, add copyright marks. Again, you could use a C without registering or going into the process of registering your technology and be able to put the R. And also along the lines, respect the use of others' IP. Get permission prior to using any IP. It seems like a tough process ahead of time, but down the road, it can protect you with oodles and oodles of lawsuits. So be careful of that. Most corporations, larger corporations, have legal departments for exactly this same reason. So that's why it's so important, and I wanted to discuss it with you. And finally, in this global society, remember that IP laws are different from country to country. So what might be a patent in the United States might not be valid in another country. That's how China, back in the 90s and 2000s, was able to get away with creating so much same technology as the United States. DVDs were the main example. It's because they weren't patented in China. So in China, they can make it without threat of lawsuit. But and so when you file for a patent in the United States, it's only good in the United States. Legal firms will help you patent throughout the world, but because that's a whole different world, but a whole different ball game. But remember, a patent is only good for specific countries that it has been applied for. So, some other examples of intellectual property. Talked about Coca-Cola. Well, believe it or not, your Kentucky Fried Chicken, that special herbs and ingredients, they're not public knowledge. That's called a trade secret. Again, this goes back because it's just simpler to protect the company by hiding what the recipe is. Marvel logo. This is kind of funny. You see, you open up your Disney Plus, because we're all stuck at home here. It's a trademark. How does Disney get to own it? Well, it's actually through a contractual agreement. They're owned by Disney, but it's operated as a separate company. So that's where before Disney uses the Marvel logo, has to make sure it's in compliance with the contract between the Marvel Corporation and Disney. So this is now, if you ever wonder why everybody, all these large corporations have all these lawyers, now you're getting into it. This is the whole reason. Boeing, one of the biggest patenters out there. They patent everything. Why? Because they sell their products to not only U.S. airlines, but other airlines around the world. What happens? Those airlines become experts in their product. So along the lines, Boeing sells a 777 to Air France. Air France sells that 777 to Airbus. Airbus deconstructs the airplane and can use all Boeing's technology. So what does Boeing do? Boeing patents everything. So that when Air France learns that all about the technology, they can learn it, but they can't have Airbus, can't sell it to Airbus. So that's the whole reason. So it's great. If you ever look in the patent office and just query Boeing, and you'll come up with everything. Microsoft Office. Now, I think actually Microsoft Office is patented. There's a lot of reasons for it, but most software is not. It's because it changes too fast. Office was patented because it has been around for so long and is such a part of the Office ecosystem. So that's why they did it. But it also allowed them to open up certain components of it. But no, most software is not patented. It is trademarked, copywritten, so that to protect those companies. All right, if you want to learn more about intellectual property, here is a YouTube video. It's a crash course. Again, everything we talked about, this is just an introduction. As you get more and more into the professional world, IP will become more important. So that's part of the reason I want to introduce you to it. Thanks for your attention, and I will talk to you in the next video.